So your client's evaluation, they have it set February 5th. Norma, on James Garcia.
Yes.
If you can put this towards the end of February, please. And if you all, Rick, if you all will make sure that he has discovery, please.
Sure.
Yes.
Thank you, ma'am.
Is that like a status conference, Jake?
Yes, but you all, while he's awaiting evaluation, you all need to make sure you have discovery.
Yeah, I'll make sure it goes all that. It's
All right, thank you.
fairly clear cut.
All right, thank you. All right, Ray Godfrey. All right, State, did you tender an offer?
I did tender an offer, but for the court's knowledge, I did receive 4 audios. But I still did tender an offer.
Okay,
Yes, Your Honor, we have an offer, but still pending some of that discovery.
all right. Ms. Ferguson, set this for the last week in December, please. All right, we're going to come back on December 16th. If your counsel has received all the discovery, then that will be your plea deadline. Sure.
Either one.
It's a Tuesday.
Did anyone could do that on Monday? Is that possible?
Yes.
Okay.
Norma,
please.
set it for Monday.
All right, thank you, ma'am. Your Honor, sorry.
No problem. So Norma, put it for Monday.
Thank you, ma'am. Your Honor.
Oh, no. No. Thank you for dressing appropriately for court and being on time.
Okay.
Oh, thank you. State, on Jonathan Ruiz, is there any restitution on that? He's on the last page, 14. All right, Mr. Ruiz, and probation on Jonathan Ruiz. All right, on this case, there is no restitution owed. So how's probation going?
Stop.
All right, is there anything that you need help with?
Not right now, no.
Judge, Mr. Ruiz tells me that he graduated drug court and he's doing really well. He's waiting right now just to be transferred back over to regular caseload to finish out his probation term.
Oh, awesome. Well, congratulations. All right, so.
This is the payoff. Jonathan Ruiz went through felony drug court, a tough high supervision program, and is now celebrating. He's got a job, an apartment, and sobriety. The judge's reaction is genuine. This isn't just a legal victory, it's a life-changing success story. But wait, there's a bureaucratic hiccup. His probation termination is stuck because of a $1,000 fee. This highlights how often administrative issues, like fees, can delay freedom even after a person completes all the hard work.
We shall see. You may be done with probation today. But no, I went to graduation. So I'm so happy for you that you graduated. So are you staying on the right path?
Yes, I got an apartment now since I've been in drug court.
Mhm.
I got a job, I've been working, so it's just been uphill from there.
Well, that is so awesome. And remember, life is going to throw some storms your way, but just continue on the path. Don't get sidetracked. And whatever you're doing to maintain your sobriety, continue doing that, because it's so easy in life to get off track. You don't do one thing and then you look up, so many days have passed and you're completely off track. So stay on that, because I don't want you to come back to court unless you're coming back to visit to say hi. Yeah, right. So we're going to see what's happening here, because you've probably done with probation. So she's going to check on that. So just remain and then we'll take care of it. Okay. Yes, just have a seat. All right. Thank you. All right. Joseph Daniel Dominguez. Hi. Good morning. Thank you for being on time and dressing appropriately for court. Your attorney is out. So what we're going to do, and we received notice of that. So what we're going to do is reset you. Let me just pull up your case just a moment.
That works perfect for me. I got a baby appointment.
Oh, yeah? How's everything going?
It's good. I got a little one on the way.
Oh.
March.
Oh, wow. That's right around the corner.
She needs a lot of money.
Well, now is the time to, get it together. Okay. Ms. Ferguson, set this for late January. All right, so we'll have you back on January 26th. Once you sign the reset form, you're excused.
Thank you, Your Honor.
Thank
Have a
you.
good day.
You too.
And then fully,
Discovery,
Judge, may I approach?
yes.
Okay, so on Mr. Ruiz's case, this is the order of transfer from felony drug court. On the original, when he was granted probation, there was an amount assessed of roughly $1,700 to a person by the name of Jasmine Romo.
Mhm.
That was the estimate that was provided to the court of repair damages. Since then, the state has contacted whomever,
Mhm.
the owner of the vehicle, and apparently they paid a deductible of $500, but they never provided any proof to the state how they paid, when they paid, or anything like that. So that's why the state's position is there is no restitution.
Okay.
So the original condition has the 1,700, that was the estimated price for it to get fixed.
Mhm.
Drug court is saying they are only, I guess, placing him back on regular supervision because of the restitution, but the state is saying that there is no restitution.
All right.
How would you like to proceed, Judge?
Well, normally when they are placed in felony drug court and they complete everything, then they are terminated because they've completed everything.
Would you like me to reach out to felony drug court to make
Yes.
sure? Because that's the latest order, and I think was recently signed by Judge Quinn.
If you'll let them know, there is no restitution. And let me look up this case just one second.
Okay, Judge.
And this is from 2022. So that has been sufficient time, I think, for someone to have reached out to the state with an amount of a restitution.
Yes,
So, yes, if you'll let them know, and if need be, I'll sign whatever documents need to be signed. Thank you.
Okay, Judge.
Yes.
I guess their main concern, they say that the restitution, if there isn't any, okay, it's fine. It's just the drug court fee that they want paid.
All right. And I believe that's 1,000. All right. Let's bring him back up. All right. So they're saying the amount you need to pay before your probation can be terminated is the fee for felony drug court.
Okay.
And so the felony drug court fee is $1,000. And I always tell people,
The judge hits a key point about the $1,000 drug court fee. He calls it an investment in the person coming behind you. This clarifies that the fee isn't just personal debt. It's a mandatory cost that funds the program for future participants. It's a necessary form of restitution that keeps the court's rehabilitative infrastructure running. But the warning about predatory lending? That's real-world legal advice to protect the client from falling back into financial trouble to pay off a legal debt.
you're not necessarily paying for yourself when you pay for that fee. You're paying for the person who's coming behind you. And somebody in front of you paid the $1,000 for you. Otherwise, when you would arrive at the program, they would say, all right, we need $1,000 now. But because somebody else paid the $1,000, you didn't need to pay it then. So if you figure out how much you can pay per month or whatever to pay that $1,000 off, once that's paid, you'll be done.
Okay.
But don't do the title loan. Don't do anything like that. That's, next thing you know, you borrow $1,000 from them and you end up owing 2 or 3. So if you're planning on borrowing it, be sure to focus on what the interest rate is. All right.
Okay.
All right. Is there anything else? Okay. Once you pay that, you'll be done. And congratulations. All right. All right. Marcos Antonio Rios.
Present, Your Honor. Morning, Judge.
Good morning.
We didn't make it to the docket, Judge, and that's unfortunate.
Yeah.
I feel bad for the court about that, but,
There's a lot that's been happening with the docket, but we're gonna work on that.
yeah.
Yes.
Judge, I was gonna ask the court, I did review the Blu-ray DVD.
Mhm.
It opened up a couple more questions that I have from various witnesses, which I'd like to talk to. I would like a continuance of maybe another week or two, try to talk to these witnesses. I know we're coming up with the Christmas holidays, but I wanted more than just a recall of this week, Judge.
All right.
Pretty pleased with sugar on the top.
Ms. Ferguson, set this for a plea deadline date on December 18th. All right, once you sign the reset form, you're excused, and thank you for addressing it appropriately and appearing on time.
Thank you.
Thank
Have a
you.
nice morning.
Thank you, Judge. Too.
I'll be right there, man.
Michael Balderas. Who's the attorney on Michael Balderas?
Step right here, sir. Make sure you speak loud and clearly.
Good morning.
Good morning.
All right, today's plea deadline date.
Today, Judge, we were reset from last week because of a discovery issue. The state is in the process of getting us that discovery.
Yes,
All right, this is going to be the final plea deadline date. There will be no further extensions. If there's some documents that you don't have that the state has, you can file whatever motion and the court will consider a motion to exclude. This is coming back on December 18th for a plea deadline date.
Perfect. Thank
All
you.
right, thank you. Thank you for addressing appropriately. Once he signs the reset form, he'll be excused.
Thank you.
Angel Cantu,
Yes, sir. Morning, Gary Rivers.
good morning. Where is he?
Andrew Cantu. He's in custody, Judge.
All right, he needs to come up.
Great. Come on up. How are you, Judge?
Oh, I'm doing great. How are you doing?
I'm doing fine. I'm cold, but
Hey, it is not cold. Stop that.
I get cold very easily, so.
Thank you. All right, what is happening with this case?
So, Judge, this is Mr. Cantu's second MTR. This is my first appearance on it. So after speaking with my client and this.
See the MTR, please.
Oh. Yes,
Yes,
Angel
Angel
Cantu.
Cantu. All right, state,
Yes, sir.
this is family violence.
Judge.
Is it a family violence?
Angel Cantu.
Oh,
It
yes.
is, Judge.
This is Richard Cantu you've given me. I need Angel.
I apologize.
Yes.
So, Judge, on this case, after speaking with state and my client, it looks like there's a myriad of concerns that the state has brought up and that my client has brought up. I've looked through, I've talked with the CLO, there's some mental health stuff going on. I wanted to see if I could have a short reset to get time to see if I can get either a hold of Mr. Cantu's doctors to speak with them or his grandparents who could at least corroborate any kind of mental health treatment going on, because I want to see the state has several allegations in there, and I want to determine whether it's appropriate whether to proceed with a contested hearing. If the court would give us more time, I would be glad for that time. If you do not want to give more time, Judge, I'd like to set it for a contested hearing.
All right. This has been pending since October 2022.
Yes,
So
Judge.
I don't understand why people are not ready to proceed.
Or Judge, I think the first MTR was at October 22, and then that one was withdrawn. I was not placed on that MTR, Judge. I don't know when this one was
Can I have
filed.
the updated motion to revoke, please?
I have this MTR shown as signed on November 3rd.
All right, November 3rd, and here it is, December 8th. I don't understand.
Judge, then we'd ask for a contested hearing.
And how long have you been on this case?
I have been on this case, I have to look, Judge.
For more than 10 days?
Yes, Judge, correct.
All right, Norma, set this for a contested hearing this month. All right, your contested hearing is going to be December 18th.
That's fine, Judge. Thank you.
All right, thank you. Probation contested hearing on December 18th. Ray Cordova.
Judge.
All right, where are we on discovery?
Judge, it was reset so that I can obtain discovery. I handed Rick a USB and he was having problems uploading it.
Mhm.
And then it wasn't big enough So we kept going back and forth. I just picked up the discovery a week ago. So I still need to finish reviewing it. And so I was asking the court for a reset.
All right, Ms. Ferguson, set this for a plea deadline date, the end of January. All right, 26. Once you sign the reset form, you'll be excused.
Thank you.
All right, thank you. Christopher Sanchez.
I'm here, Your Honor. He is still at the Bear County Jail. And we're just
Yes.
asking to recall for tomorrow. I have to be here on 2 other matters.
Okay. All right, Deputy, that'll be recalled for tomorrow.
Thank you, Your Honor.
You're welcome. Matthew and Siriaga. All right, so the plea deadline date is today.
Correct, Judge. What I'm asking the court for is one more plea deadline. We're still negotiating, and I think we should be able to reach a resolution.
All right, so we'll recall this back for December 18th. All right, once you sign the reset form, you're excused.
Just have to see.
All right, thank you.
Thanks, Judge.
You're welcome. Yes. Benjamin Santa Maria.
Morning.
Good morning. So has all the paperwork and everything been filled out?
Yes, Judge, he's been accepted to PTD.
Mhm.
I have mailed back the contract. We're just waiting for them to contact Mr. Santa Maria with the orientation or whatever is next.
They have already contacted me. We already set orientation in December.
Everyone, please whisper like you're spies. And if your conversation is heard, you will be executed. All right, yes.
December 1st for the orientation.
All right, Ms. Ferguson, I need a PTD date.
December 5th. January 5th.
All right, January 5th. Once you sign the reset form, you're excused.
Thank you, Judge.
You're welcome.
Thank you.
Yeah.
Court is calling 2025 CR 014148, 2025 CR 005762, State versus Brian Mahan. Could I have parties approach and announce for the record?
Morning, Judge. Alex Starr for Mr. Mahan. He's present. Ready?
Great. Thank you for dressing appropriately for court.
You're welcome, Your
Attorneys should take notice.
I appreciate it.
All right. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Probation, there are applications. And each of the cause numbers, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, sir.
And each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Judge.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State in cause number 2025 CR 014148. Are you proceeding on the indictment as presented?
Yes, sir.
And in cause number 2025 CR 005762, are you proceeding on the indictment as presented? And each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
These charges are serious. Evading arrest with a prior conviction, elevated to a potential 10-year prison sentence, and burglary of a building. But listen to the plea. The state agrees to remain silent on the punishment and caps the potential prison time at 5 years. The defendant is pleading guilty to 2 felonies, but in exchange, he gets a shot at probation. The fact that he's waiving the PSI and opting for a quick sentencing hearing in January shows he's anxious to get his fate decided, or confident in his mitigation evidence.
Yes, sir.
And cause number ending in 4H, you're charged with evading arrest, detention with a previous conviction as a repeater. Normally, that's a state jail felony, but if the state proves up the enhancement, the range of punishment will be anywhere from 2 to 10 years in prison and up to a $10,000 fine. And the cause number ending in 6-2, you're charged with burglary of a building. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of the cause numbers?
Yes, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Mahan, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
I am.
By entering into these pleas, if you're not a U.S. citizen, you could be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, in each cause number, the state will remain silent. The cause numbers will run concurrently. The state will take in consideration 2025 CR 005763 and cause number ending 48. There's a cap of 5 years in the prison, a $1,200 fine. And the cause number ending in 62. There is punishment to be assessed at 2 years in the state jail facility, $1,200 fine, restitution to David Hill, and restitution to Chad Topperwine in 2025 CR 005763. Did you understand that to be your plea and each of the cause numbers?
Yes, Your Honor.
Defense is at the plea?
Yes, Judge.
State is at the plea?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? You need to speak up.
Yes, Your Honor.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge.
And cause number ending in 62 outside the agreement, there's to be no contact with Cube Smart Self-Storage at Vance Jackson, Store Self-Storage at 2515H 10 West, and no contact with the complainants under each of those cause numbers. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your
Then in each of the cause numbers, how do you plead? Guilty, not guilty, or no contest?
Honor. Guilty.
State in each of the cause number, any evidence to support the defendant's plea.
Yes, Your Honor. She offers state to report and all of that.
No objection.
In each of the cause numbers, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes,
Did you understand it and sign it in all the appropriate places?
yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. In each cause number, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. All right, we can go off the record. I'm sorry, state, you're excused. If you want a PSI and TAP evaluation, it'd be 8 to 12 weeks.
Yes, Judge.
Otherwise, if you want, we can bring it back sometime in January. And if you want to just present witnesses to the court, you can present witnesses. Which do you prefer?
What does the court prefer? Do you want would you prefer a full-blown PSI or?
It's completely up to you. You would just present whatever evidence you wanted to present. Otherwise, with a PSI and TAP evaluation, you know what I'll receive.
We could do it in January, Judge.
All right, are you waiving PSI and TAP evaluation?
Yes.
All right, Ms. Ferguson, I need a date in January. How much time do you need?
It's really just getting with the witnesses and making sure,
Okay.
I would say, mid second or third week of January.
All right, Ms. Ferguson, I need a third week of January. All right, we'll be back on January 20th. At that time, I'll make a decision on your application based upon whatever witnesses are presented.
Yes, Judge.
Thank you.
Thank you, Your Honor.
Have a great day.
All right, thank you, you too.
He's on several pages, page 3, page 5. page
Vincent
6.
Gonzalez. Hi, counsel. All right, so Today is the plea deadline date. However, there's an issue. I'm being told they lost the keys to the bus. So some inmates have not been transferred yet because they only have the one van. So do you have any idea what your client's decision is?
I'm missing discovery on one of Mr. Gonzalez's cases. I've conferred with the state. They're in the process of producing us a discovery.
All right. All right, Ms. Ferguson, extend this plea deadline date to the 18th.
8th of December?
Yes.
Thank you.
All right, thank you. All right, Marciniak. All right, today is plea deadline date.
Yes, Judge, we've received an offer and we've rejected it.
Okay. All right, state, how long do you expect this jury trial to last? All right, Norm, I need a jury trial date, 3 days.
And Your Honor, there's, we've just been disclosed, haven't received CPS records. I just told about it.
The disc is here. We're having a copy today. I'm printing out the protective order.
All right, thank you. Jury trial date, 3 days.
February 24th, Judge.
All right, your jury trial date will be February 24th.
Thanks, Judge. Also, just for the record, there are some potential SAPD offense reports and investigations of the complainant. The state tells me they're going to get me those before trial.
All righty.
Thank you.
You're welcome.
You said the 24th?
Yes.
Yeah.
All right, Deputy Laura, you can line them up.
Looking at my calendar, Judge, I have a federal sentencing on the 24th for a guy who's been waiting for about 9 months in Del Rio.
Okay.
If I don't know if there's maybe another day, it would be.
All right, Norma, recall this for February 23rd.
23rd?
Yes.
Perfect.
Thank you.
Thanks, Judge.
Hello.
Thank you.
You are wearing my high school colors today. The only thing you mentioned missing is the touch of gold.
A little bit there, Judge.
All right, let me just put this in the system. Defense, on this trial, state if you'll remove yourself from that table, please. And defense, if you'll have your witness in here. Today is plea deadline date.
On him?
Francisco Alvarado?
That's news to me, Judge. He wasn't even on Odyssey.
No, he had discovery date on November 20th.
Well, Judge, I just got an offer today from Miss Albin. Can we get a?
Yes.
And they said he wasn't even on Odyssey. I don't know what is going on.
Okay. All right, Ms. Ferguson, recall this for our last date in December for plea deadline date.
Judge, I'm sorry. Yeah, I'll be out of state. Can I appear by Zoom?
Yes.
Okay. December 8th.
All right, and Mr. Alvarado, you can appear by Zoom as well.
You know what Zoom is? Okay.
The court is going to call 2025 CR 007810, State versus Catherine Marie Flores. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Defense?
Megan Enriquez, present for John Coons for Catherine Flores.
All right, are you Catherine Flores?
Yes, ma'am.
Do you have any objection to this attorney standing in?
No.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. And counsel, do you have any objections to the state appearing by Zoom?
No objection.
Ms. Flores, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
This is a massive reduction. The state is waiving the peace officer enhancement, meaning this charge drops from a felony level back down to a Class A misdemeanor, assault bodily injury. This suggests the evidence didn't fully support the severe charge, or the prosecution is sympathetic to the circumstances. The plea agreement is now manageable, 1-year probation. This shows the value of strong defense negotiation in high-emotion cases.
No, Judge, we move to waive the peace officer enhancement and proceed on the misdemeanor offense.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser for the offense of assault? It's a misdemeanor. The range of punishment is up to 1 year in the Bear County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
No contest.
No. Do you understand you have a right to jury trial?
Oh, yes, ma'am.
Do you understand you have a right to remain silent?
Yes, ma'am.
Do you understand you or your attorney can cross-examine any witnesses the state would call?
Yes, ma'am.
By entering into this plea bargaining agreement, you are not going to be doing that. Do you understand?
Yes, ma'am.
And did you intend to enter into this plea bargaining agreement and give up those rights I just mentioned?
Yes, ma'am.
Right. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Flores, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering into this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor. They're asking that your punishment be assessed at 1 year in the Bear County Jail. There's a $1,000 fine. There's no application for deferred adjudication. The state is recommending community supervision. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, Your Honor. I wanted to mention one thing. When we were filling out the paperwork, I noticed that there was not a spot to check off I am a United States citizen like there normally is, but we did go over it.
Yes, they don't do that anymore.
Oh, okay. Perfect.
Yes.
Things have changed in 3 months.
Oh, it has.
Okay, I did advise her and she understood. Interesting.
So, all right. Did you understand that to be the plea?
Yes, ma'am.
Did you review the waiver of appeal paragraph? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 200 hours of community service restitution, hostility management course, and a mental health evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offer states 1 in attachments.
No objection.
All right. And state, have you had a chance to speak with the client?
Yes, Judge.
All right, state, you may be excused. Thank you.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're very grateful to Ms. Galloway and the state for taking a look at the evidence. She does have a young child. She's no longer with the child's father, so she works to support him. So if there's any way that the court has any ideas for her to satisfy her community service hours or ways that she could buy out of it or satisfy it in another way, we would be grateful.
Okay. Are you employed?
Yes, ma'am.
What do you do?
I work at a hotel here downtown, doing front desk.
Okay. And have you ever had any prior mental health issues or diagnosis?
No.
All right, so what was happening this time?
I just
She confesses the core issue. She was fed up with an abusive relationship and felt overwhelmed. But then she directly challenges the arresting officer, claiming the officer yelled at her and hurt her. This is a crucial defense narrative, that her criminal act was a reaction to emotional distress and perceived mistreatment by the officer, not a calculated attack. The judge's response, ordering hostility management and mental health evaluation, acknowledges the underlying emotional issue.
Felt like overwhelmed with my relationship. I don't want to get too into it, but it was kind of like mentally abusive, verbally abusive. I just felt kind of like fed up at the moment. That day I was supposed to go into work. I called in because we were arguing. And I was supposed to leave, and whenever I was leaving, the officer got there. And right away, I guess they saw me as like the aggressor because I was just, crying out of it. And, they just detained me. And from there, with the officer, she put me in handcuffs. When she put me in handcuffs, I let her know that she was hurting me a certain way. I communicated that to her, and her response was just kind of like, shut up. And she yelled in my face, and that was just my reaction. And it's not the way to react to things, but I just felt mentally drained.
Sometimes you did it. Sometimes when you're having one of those days and everything hits you at once, and then sometimes this is the last thing and the last straw. But
I do want to apologize to the officer, by the way. Wasn't my intention at all.
But you'll have to do better and make better decisions and remain calm. All right. So the court is going to sentence you, as previously stated, 1 year in the Bexar County Jail, suspended and probated for 2 years, $1,000 fine, that will be probated. Proof of employment within 45 days, no employment as a home health care provider or with minors, 200 hours of community service restitution. 50 of those hours will be deemed satisfied. I'm going to order parenting classes. Once you complete the parenting classes, 50 hours will be deemed satisfied. The other 50 hours will be deemed satisfied once you complete the hostility management course.
The sentencing is complete, but the judge introduces an interesting condition for the final 100 community service hours. Write a letter of apology to the officer. This is a condition intended for restorative justice, forcing the defendant to internalize the impact of her actions on the victim, the officer. The final warning about reaching out if the walls are closing in shows the judge is serious about addressing mental health as a core condition of successful probation. What do you think about the letter of apology as a form of community service? Would that help the officer, the defendant, or neither?
The walls are closing in for you. Let your probation officer know. I don't have them file a motion to revoke because someone is reaching out for help. Okay. And whatever you do not disappear. All right?
Okay.
All right. Do you have any questions about anything?
No.
All right. Probation is going to go over your conditions with you, and then you'll be excused. Good luck.